Thanks, Senator McKenna.
Thanks very much, Chair. Actually, Dr Rimmer raised it already, the issue of labour rights. And a number of trade unions have mentioned to me their concerns with ISDS. Can you just elaborate on what you meant there when you said that you were talking about in the context of the American Congress, how an ISDS could impinge on labour rights in a country like Australia?
Sure. So there have been a number of submissions, both my submission and a number of submissions from particular unions, raised concerns about the role of investor-state dispute resolution in relation to matters of industrial relations. And from an Australian perspective, it's been bubbling along for a few years. From the ACTU, raised concerns about investor-state dispute settlement a few years ago. A lot of interest in the case of Veolia versus the Arab Republic of Egypt, in which a French multinational company launched a claim against Egypt over labour wage stabilisation promises, as well as a terminated waste contract. So there has been instances in which investor-state dispute settlement has been deployed in relation to questions about labour rights. There has been...
So is that on the basis that a country's labour laws, for example, Australia's labour laws, could in some way impede the ability of a foreign investor to make a return on their investment? Is that what the basic line is?
Well, the concern is decisions in relation to labour rights have adversely affected the foreign investments of a company, and then that provides them with a basis for a complaint. Trade unions have been quite concerned both about the general operation of investor-state dispute settlement in relation to labour rights, but there's also been a bit of debate about exceptions, defences, safeguards, particularly in relation to labour and safety. The European Trade Union Confederation has been very adamant that there's a need to reform the investor-state dispute settlement process, particularly to ensure that investors comply with relevant ILO core labour standards and other human rights. So from that perspective, there's a concern about the interaction between investor-state dispute settlement and the international regime in relation to labour rights. So in some ways echoes of the battles over investor-state dispute settlement and health and international health law. There's a similar parallel concern in that context. In relation to the United States, the Democrats are very upset with the Obama administration because the Bush administration needed Congress to do trade deals, and the Democrats, particularly led by Henry Waxman, were able to secure statements about the need to protect labour rights in some of the trade deals. Obama has not necessarily made any similar commitments, and that is a real tension point at the moment in terms of the relationship between the Obama administration and the Democrats in the US Congress. A lot of the big unions in the United States have been heavy lobbying the Congress not to accept the Trans-Pacific Partnership unless and until questions about labour rights are dealt with. But it's quite an interesting issue. A number of the submissions to this committee also raised concerns about privatisation. So I think the New South Wales nurses and midwives were concerned about investor-state dispute settlement, supporting the privatisation of healthcare. Some of the educational unions were concerned about investor-state dispute settlement being used to support privatisation of education. So I think a lot of those organisations have been very concerned about how foreign investors might use investor-state dispute settlement as a Trojan horse for certain sorts of deregulation of labour standards and rights. But there's a big battle always in terms of jobs and employment and whether or not trade deals will adversely or positively affect jobs in a country.
Yep. All right.